Arthur, the show is yours, and I know it's going to be a show.
So you've brought me here for comic relief, have you? It's a good thing you're an ex-dean. All right. This is a conference on aggregate litigation, and now you're going to have a panel about the individual. Who cares about the individual? Well, I think we've got a panel of 5, each of whom does care about the individual and will offer us thoughts. Tom, do you want to start?
Each of us is coming to this from our own perspective, and my perspective is I'm a researcher who goes out and interviews litigants. So what I bring into this is I know what it is that causes people to be satisfied or dissatisfied when they go to court or deal with the police or pretty much deal with any kind of legal authority. And one obvious question for us to ask is, why would any of you care about that? I think that there are a couple of things that are important here. One is obviously, why would people be satisfied or dissatisfied with the resolution of some claim? Especially in civil litigation, people have the right to control their case. So what causes them to feel satisfied and to walk away and feel good? The other thing that has been more and more important lately is, how do they feel about the legal system? We all recognize that we're in a crisis of confidence about American institutions. You just look at the presidential race and you see the best qualification to be president is you've never been a political leader. So that's something about the way people feel about institutions nowadays. So we want to ask, what causes people to feel good or bad about their experience in these situations where we're talking about aggregate litigation? First thing I would say is that we know that people are disgruntled if they feel they have a case and they have trouble bringing it to court. California did a study and found that about 25% of their population said they had had a grievance they wanted to bring to civil court and they didn't do it. Mainly, they said, because they didn't have the resources to go to court. And those people are clearly lower in the surveys in trust in the courts and the government. On the other hand, we have people like Justice Breyer telling us that we need trust in the courts to make communities work. Research tells us that when people trust dispute resolution mechanisms, they engage more in commerce, they engage in community activities. So we're losing something here if people don't trust the courts. One thing we might say then is we want people to be able to pursue their grievances. And that's a simple way to think about why aggregate litigation might be a good idea. It builds access opportunities. People can't do it on their own, but they can do it as a group. So it's a way to build trust in an era of distrust. Of course, going to court is not in and of itself a solution. People have to get what they feel is fairness. And we know a lot about what they mean by fairness. They want to have an opportunity to voice their concerns, present their evidence, and they want to feel that there's a neutral, principled decision maker. The good news is there's no evidence that people want to be personally present in court. And mediating through an attorney is fine as long as they get the message that the court actually had those characteristics. So that's very good for the idea of aggregate litigation. On the other hand, one of the things that aggregate litigation is a problem for is another set of things that people want. They want to be listened to by an authority that they feel acknowledges their problem, acknowledges their injury, and seems sincerely interested in trying to address their concerns. Obviously, that's not going to happen if they're not there. One of the reasons that I think Ken Feinberg is very interesting, and Judge Weinstein, who he worked for originally, is although Ken didn't mention it this morning, they did a lot of individualized hearings in the 911 and Agent Orange cases. So they did a lot of giving people forums to display those kind of feelings. And so one of the issues for all of us, I think, is how could we ever institutionalize that And if we don't, are people going to be satisfied with aggregate litigation? I'll just throw out one idea that I think is a very interesting idea. There's a lot of discussion about pro se litigation, and I know that lawyers and judges don't tend to like it, but I'm going to advocate thinking more about social pro se litigation. One of the things that we know is that if the people who have common injury, common background, common cause join together as a group, a lot of the functions that Judge Weinstein or Ken Feinberg performed, the social emotional functions, get managed by the litigants. And so those can be managed by the litigants themselves and don't have to be something that a judge has to deal with. The point would be, we should think about trying to find ways to encourage the parties to join and work together as a common group, to meet both those concerns, and because when people work together as a common group, they end up feeling better. There are a lot of emotional benefits. There are a lot of benefits in terms of their well-being. And I would argue that there are a lot of benefits for society, because aggregate groups are a tripwire for underlying societal problems. We don't want them to be swept under the rug. We want people to be able to address them. And if we think about how to design aggregate litigation from the point of view of the litigants, we can get that important function at the same time that we also can address people's needs and build their trust in the legal system.
No, I think it's very useful. My question would be, what about small claims? I mean, everything you're saying makes a lot of sense if we're talking about people with pretty substantial claims, but a lot of the discussion in this room has been about situations where you've got massive numbers of people with very small claims. How does it change?
Judge?
I think you have to distinguish between satisfaction of lawyers and satisfaction of litigants. In many of these areas of small claims, which are statutory claims, these are lawyer-generated cases, not client-generated cases. The person who's been dunned by a bill collector who may be too aggressive can be a very aggrieved and necessary litigant. But all too often, these are technical errors that bill collectors make, and lawyers pounce on them. The lawyers that litigate disability claims against restaurants are perhaps imbued with a zeal to get public benefit, but more often than not, it's a cottage industry. In my 9/11 experience, there was terrific resentment against the lawyers who were accused of not paying attention to the clients. And a lot of the things I did in that case were done specifically to get the people to understand what they were doing and what was happening to them, and that it was their claims and not their lawyers' claims. What you say, Tom, is very, very important, but it's important to distinguish the kinds of claims and where the satisfaction is. Is it the lawyers or is it really the clients?
Jay?
Sure. So I'm in agreement with the idea, as you think about the different kinds of strategies that you can use for ensuring or enhancing, empowering the individual within the aggregate. I think the standard strategies are loyalty, voice, and exit. And I know you've talked a fair amount about voice and how you give more voice to the individuals. I'll talk a little bit more in my own remarks as well, but I think, thanks. I think there's also a need for to strategies that ensure loyalty, and I guess a question I would have is if litigants believe that their lawyers are loyal, that in fact they're looking after their own best interest, does that increase satisfaction significantly, or is it important independently that they be given voice?
Okay. Well, I'm sorry. Go ahead.
No. I mean, I can say it now, or I can say it in my remarks, but maybe, all right, well, okay. So, yeah, I think this is important to do, right? It's also costly to do. So the question is how much cost do we want to assume or incur in order to have these sorts of benefits, these kinds of what I'll call psychological benefits in terms of feelings. The problem, one of the problems with thinking about feelings, and I think a lot of this is very valuable. A lot of the problem with thinking about feelings is that psychological sort of benefits like this is that it really does slide into utilitarianism. I mean, for example, if it's going to cost something to have preference satisfaction in litigation, well, then ask the question, okay, maybe those resources are better spent having better schools. The point is that when you're trying to satisfy preferences, you end up normatively driven, unless you have some special reason to care about these preferences in particular, in which case you've got to have a normative theory about that. You get driven to a sort of more utilitarian approach, and then you don't really have traction against a lot of what else happens.
Well, I think that one way to look at this is that we could try to retrain lawyers to think about more than just winning cases and trying to build their approach to clients around a better understanding of what clients want, which often is not just to win a case, but rather to have their situation acknowledged and recognized and have some sense they're dealing with people that are really interested in them. I don't think it's unusual to hear clients saying that lawyers are only out for themselves and don't care about them. That is something that then means that those lawyers are not really addressing the client's concerns, and we can think of a lot of different ways to try to address that. We can try to work with lawyers. We can try to create a different institutional framework where we have different ways to address those needs. I think there are a lot of advantages to trying to get the clients more involved as a group in meeting those sort of concerns. Ultimately, it's for all of the people in this room and actors in the legal system to decide whether we care if the public trusts the courts. But if we do care, then we want to talk about what we can do to build that trust, and that's where this kind of research, I think, is important.
Are you throwing it back to the law schools to educate youngsters as to how to behave with clients?
I think all law schools should hire psychologists and put this on their curriculum.
I see. I mean, as I get older and older and watch the curriculum get more and more pressurized by the nouveau courses, I wonder where you would fit this in, unless you want to go to a fourth year of legal education. Or
Well, I'm not against a fourth year of legal education, but
I'm against a fourth year of legal education.
I mean, I think the message from research on litigants is a really pretty simple message, and that is litigants are not really aggrieved at lawyers because they think lawyers don't understand the law or are not doing a good job on legal issues. They're aggrieved at lawyers because they don't think lawyers care about them and are acting in their own best interests, that the lawyers are doing what's good for the lawyer and not for the client. The judges, and you just heard another example, often because of their role transcend that, and they become the people who try to talk to the litigants. Judge Weinstein did that, Ken Feinberg does that, and I think the point is that it's because that is going on that there have been these successful examples of aggregate litigation in complicated cases. And as everyone said all morning, it's hard to institutionalize that, but it's also important to recognize that if it weren't going on, we wouldn't be seeing these successes. We'd be seeing a lot more angry clients.
Sheila, did you want in?
Well, yeah, I mean, in these multi-district litigations where you have 15,000, 20,000, 40,000 plaintiffs, believe me, no plaintiff has an individual relationship. They got those clients mostly through ads on the internet. The lawyers never even meet with them. They don't see them. They don't talk to them. Paralegals do all of that work. And it's only if the case is a test case that gets picked at the end of the day that there is anything like a relationship of attorney-client at all. So, I mean, their individual satisfaction is a very nice thing to talk about, but in these kinds of cases we're talking about multi-district litigation, there's just no individual relationship as we know it or used to know it. And these people, yeah, I mean, with Judge Hellerstein, when I was his special master in 9/11 cases, We had, and I was mediating about 93 cases. In many instances, the case would not settle until they talked to the judge. They had to tell the judge their story. For them, it was very personal. That wasn't mass litigation in that sense. These were 93 people who opted out of the 9/11 settlements and wanted to bring their own cases, and that made this a very emotional thing for them. And until they spoke to Judge Hellerstein, they would not settle. Once they spoke to him, they settled. They just had to tell their story to the judge. So I think there are cases where that is true, and the judge's input or the mediator's input becomes very important, and it's a one-on-one basis. But most of these mass torts are not being settled anywhere close to a one-on-one basis.
Carolyn?
So individuals in aggregate litigation at least have some access to the adversary system. In our court, the largest trial court in the country, well over half the cases have at least one litigant that is self-represented. And when I say half the cases, I include all the criminal cases where, as you know, both sides are represented. And so aggregate litigation exists within the context of a very, very real problem, because I don't think you can say that that large swath of people who have no representation actually are participating in an adversary system. I was struck by your statement that we want to encourage plaintiffs and defendants to try to work together in some cohesive way. I would suggest that if we want to do that, we do not do that under the rules of civil procedure because they are not designed for that. And I think they have restricted access for all of those people that are currently unrepresented in our system.
There are some situations in which what Tom suggested, and in a way Judge Hellerstein seconded it, where the group can function. In a pollution case involving ground contamination, Beth mentions this in one of her articles. I was actually involved in the case. Everybody was proximate. They all lived in the neighborhood affected by the contamination. And they organized themselves, with the help of the lawyers, into group leadership, various function. They met periodically. I went out there and gave lectures and interacted on what the case was about and the nature of a class action and what they could expect. And people affected by ground contamination are not happy people, but I'd like to think that in the end of the day, they were happier. Now, that isn't going to work in a dispersed pharmaceutical type case, but maybe the system should pick and choose those instances in which you can get a group function. Or maybe it ain't worth the candle, which is the reality of modern life.
So I wanted to tie together, Bob Bones, how much is it going to cost with Tom Tyler's concerns and actually also with Judge Kuehl's point. In individually retained plaintiffs' attorneys exist in some of the MDLs. The structure of compensation in an MDL, which judges have something to do with, can help pay for the provision of ordinary legal services to some of those people. In some of the MDLs, which involve monetary damage and distribution, there's some individual lawyering about whether it's estates or who's qualified or how you get the money or the like. And so if attorneys' fees were structured so that the planning steering committee got X%, but the individual lawyers, if they showed lawyering, got Y%, you would then be able to deal with the cost of it because you're taking the universe of attorney's fees and reallocating it to those who are delivering one-on-one legal services, and you could respond not maybe to all 40,000, but you could start trying to marshal. You'd also, for Sam's comments, create incentives for lawyers to provide this form of legal representation and redistribute some of the funds. So I think there is more play for actual economic funding of lawyers if judges took it on in a way that was aggressive vis-a-vis the distribution of the fees and costs that are inside these cases.
All right, let's get a second member of the panel going. Robert?
Yeah, I'm sort of caught in the dead space between these two, but maybe what I'll do is I'll do this one. That way I can look this way. I can slide over as well, yeah, exactly. Okay, and I'll be as brief as I can with this. So my main point, I suppose, overall, is that we have some theoretical questions we have to answer, and they're tough questions, and it's not easy to answer them. I'm going to suggest a way we might approach it before we can actually decide what role the individual ought to have in the aggregate, how much control or power that individual ought to have, how responsive the litigation system should be to individuals in an aggregate context. We just have some prior things we have to sort out. It seems to me there are two broad approaches to think about this, and it's just the way I've structured my own thinking and procedure over the years. One is sort of a functional outcome-based approach, and the other one is an intrinsic process-based approach. So from the functional outcome-based approach, what you're doing is you're saying, okay, we have aggregations, they serve certain goals, they have certain functions, right? They have certain benefits, they have certain costs. The benefits and costs are cashed out largely in terms of the quality of the outcomes that are produced. And I mean outcomes broadly speaking now. For example, satisfaction, satisfied litigants may be a kind of outcome we want to have. And if it is a kind of outcome we want to have, then it's obviously built into this approach. So something like voice, something like participation of the sort, and the psychological benefits that flow from it of the sort that Tom is describing could well be valuable in this approach. But what we have to do is figure out, because all of this costs. There's costs to all of this. I don't just mean the money you actually have to spend to give people voice. I mean the lost opportunity costs as well in investing time and effort in this particular enterprise. So given that, we have to have there's a prior decision we have to make, which is, what is the point of adjudication? And I know that's a very deep question, and obviously there are conflicting views on it. But implicit in whatever view we have of this, we have an implicit view of what adjudication should be, what it's about. And it seems to me it's worthwhile trying to squarely address that question as best we can, or at least be open and transparent to some extent with the assumptions we're making about it. But I don't think once we've resolved sort of what aggregation is supposed to do on a functional outcome-based perspective, there's a lot of tricky questions. But at bottom, the individual's participation and their role in the aggregation is credited to the extent that it serves or furthers those goals. So there's nothing really intractable about the problem. Once we develop what the goals are, then the individual, so for example, we may want individual participation in order to signal judges, for example, that settlements might be awry. We may want to have objectors have an ability to object or a broad ability to object for that reason as well, et cetera. So everything's functional in that sense. Now, of course, the other approach is the intrinsic or process-based approach. Now, that one's much more difficult, right? That travels often under the heading of the right to a day in court. That's Taylor v. Sturgill and whatnot. The important thing here, of course, we're all aware of, is this is not a utilitarian concept. This is a right. It has traction against utility. If it didn't have traction against utilitarian maximization of social welfare, then we really wouldn't be gathered here in with such an intractable problem. That's a whole other thing, but that right to a day in court is a right that checks or limits to some extent a broader social welfare analysis. So the question is, what is that right to a day in court? How we deal with it? Because the right to a day in court from a process-based perspective, from the rather broad perspective that the Supreme Court seems to look at it from, really is in tension then with a lot of the objectives we're trying to serve through aggregation. That really sets up the tension. And Bill, talking about legitimacy, has sort of traveled down this road to some extent. So how do we try to resolve that tension? Well, we have a number of strategies we use, and I don't think any of them works very well. For example, we rely on consent. So sometimes we say opt-outs and class actions are consenting, and of course we all know that just doesn't work. Secondly, in MDLs, we say, well, they have their lawyers. Well, we've talked about that. To what extent is that agent really giving meaningful consent? Another way we look at this, right, is we say representation. But representation is a very awkward concept applied to this kind of day-in-court participation idea. I mean, what in the end of the day does it actually mean to say that somebody in a litigation is somehow representing my interests in choosing how to conduct that litigation? It just doesn't work on that level. Of course, we then slide into outcome-based, but we have to be careful when we make that slide, because we've given up on that process-based right to a day in court. And of course, the Supreme Court has told us not to give up on it. So the third thing we do is we talk about cohesiveness. And in the cohesiveness context, we're sort of saying, well, if it's groupy enough, if it looks like a group, we can treat the individual with sort of giving them less of a role. Well, I don't even know exactly what that means, right? And that slides very quickly into something like commonality, which then becomes efficiency and a more utilitarian approach. And we have to be careful when we make that slide, again, because if it really are taking process-based views seriously, then we've got to address it in a square way. So what's the way I would see getting out of this? I basically say, look, what all this forces us to do is actually take a look. Examine carefully what the content of that right to a day in court is, right? What is it? You have to get inside it. And the reality is, if you look at the way, in fact, participation has worked historically in our litigation system, we actually get a lot of clues to what that right to a day in court ought to look like, what its content ought to be. Turns out, of course, as we all know, that we limit participation rights in lots of ways, and we have historically. And it seems to me what we can do when we think about what that day in court right is we can approach it basically from a sort of constructivist approach, which is we sort of try to construct our best principles given what our precedent and our practice has been. That is to say, the well-settled aspects of it. And I think what we discover then is that this is actually an institutional right that takes account of lots of factors. And notwithstanding the Supreme Court's insistence on this being rather broad, I think in fact it actually is fairly flexible. And it would accommodate a lot of aggregations, but at the same time, to the extent we think this is valuable, and I think it is, to accommodate the sort of things Tom's talking about as well.
Robert, do you have a working concept, definition, a one-liner on what is a day in court?
Gosh, if I had that, Arthur, if I had yes, it's an institutional right. It has traction against utility, but, so, no. I don't. I don't have a one-liner. I do have, however, a method of thinking about this, and I have certainly written, and I'm happy to talk about it, actual concrete examples of how this would work out. And I think it takes account of things such as fair regard for other litigants. So it embodies a fairness concern. If you take the B1, for example, class action. What's that all about? That's all about fair regard for other litigants, right? It's not about necessity in any sense, right? I mean, Marty's right about this. Marty Reddish is right about this. A B1B limited fund class action isn't about necessity. It's only necessity because we say normatively it's necessary. Why is it normatively necessary? Because we assume that litigants ought to have fair regard for the fate of other litigants, that in fact some kind of equality, fair regard idea is embedded in there. Well, you can spin that out. That's an important principle that you can spin out in important ways.
Why is it so hard? It's the right of a person, to have his claim presented and heard in a court. Why is that so hard?
If it were just that, we really wouldn't have a big problem, right? In MDLs, for example.
You have a problem every time there is a lawyer who doesn't pay attention to his client. Or a client who doesn't act fairly and candidly with his lawyer. Or a judge who's too busy to hear it, or a jury who's sleeping.
Well,
you can't, this is an easy proposition to state, but a very difficult
But embedded in what you just said is a lot of control, a lot of involvement, a lot of things besides just presenting a claim. And that, of course, is the gist of it. That's the guts of it.
It's just the gist of what?
That's the guts of it. That's what we have to...
The ability to present a claim.
But what does it mean to present a claim?
Yeah, well, that's right. I look over at Judge Rosenthal, who will shoot me a dagger or two, Because I would argue that cases like Chamblee and Iqbal and plausibility pleading deny people a right to a day in court when there's information asymmetry between them and the defendants, and they're bounced out because they're not plausible. It's an elastic concept, day in court.
You don't want me to, you,
Oh, you can do whatever you want. I'm
I
just
think other
directing
people
traffic.
maybe want to weigh in.
Just protect me against Judge Rosenthal, that's all.
Arthur, you've done that yourself very well for these many years. You look remarkably unscathed.
Just old, huh? Unscathed but old. Panelists, how do you react to Bob?
The problem about Iqbal and Chamblee is the congressional decision to make it very hard for a plaintiff to state a case in a securities law situation.
At least that's a congressional decision under the PSLRA.
That's
Let's
right.
not get off into pleading. It's just, I was just trying to underscore this concept of a day in court. A day, I mean, we would love to give each of our citizens a day in court. And we're slipping through aggregate litigation, maybe out of reality, to it being a virtual day in court, not a real day in court. And as Carolyn said earlier, our civil procedure rules don't really have the flex in them, or at least not as they're being construed today, to give everyone that literal day in court. Sir.
So I think it depends, Arthur.
Oh,
on,
you're not a sir, you're my colleague.
Oh, yes. Well, I was so flattered that the relationship had blossomed to this point, Arthur. But I think it depends on what happens when you get your day in court. Is the day in court the ability simply to present your claim and have it broadcast to the world, almost like an affirmation that you, in fact, have come forward and you're petitioning, almost like a First Amendment right to petition? Is the day in court the ability to get information from the other side, to force the other side to explain some decision or some undertaking that they have done that you claim has hurt you as the plaintiff? Is the day in court simply better adjudication, attention to you as an individual, that the court is really working through your case and not just an issue that's disembodied, almost a dedication of greater resources and adjudication? Or is the day in court simply pay me for my claim at the end of the day, or get me relief at the end of the day? And I mean, I could think of maybe even other things that are wrapped up into that phrase, day in court, and it really depends on which of those strands you want to pull on when you start thinking of what that means.
You have no answers?
Of course not. I do have one anecdote, though, which I see Judge Robreno over there, and he won't remember this, but back when I started practicing more than a decade ago, the very first case I worked on was a September 11th case, which was filed by a woman represented by a sort of odd plaintiff's lawyer. It was filed in the Eastern District of Pennsylvania before Judge Robreno. And this was a bizarre case. We couldn't figure out why the plaintiff had filed. The firm I was at was representing the Council on Foreign Relations, which was included as a defendant in this lawsuit. The plaintiff's claim was essentially that the Council on Foreign Relations and a bunch of other defendants had given negligent foreign policy advice to the president, which had led to September 11th. And it was a crazy claim, but she had real injuries. Her husband was on one of the planes that had crashed into the World Trade Center. And what happened after talking to her lawyer, it was clear that she wanted information. This was before the September 11th Commission. She just wanted information. She wanted to know how it came to be that terrorists had been able to strike the U.S. That's what she really wanted. And once we were able to get to that point, we were able to convince her that, you know, our clients don't have any of that information that we can give you. And she dropped the suit, and she later filed for a claim through the fund. But that was a real revelation to me, that her day in court was not really about the money. It wasn't really about even presenting a legal claim or a theory for relief. It was someone explain to me how the hell this could happen. That's what she wanted. She wanted an explanation, and that's what the day in court meant. But you can see, you can turn the diamond and get different facets for different plaintiffs, for different situations, for different types of harms. It really depends on the circumstance.
Yeah, and that ties with what Tom was saying in his presentation. It's not necessarily the dollars at the end. Having a modest involvement in the Holocaust litigation. The Holocaust litigation was not about money. Most of the people, at least the Americans in that class, were doing, it wasn't a class, but were doing very well. They simply wanted to be remembered, that their loved ones who had perished had stood for something in their day. It was about remembrance. Jay?
So also, Bob, I was interested, you've talked, I think, or you've put this principally as the tension between the right of participation and then the more sort of utilitarian perspective. I could cite a fellow by the name of Robert Bone who also said that there's a third perspective that ought to be considered, or a third perspective you can use, and that's the right to an accurate outcome or an accurate determination as being a right. And it seems to me that if, this is to pick up on Bill's point to some extent from this morning, but if preclusion of a claim is the consequence of an action, then isn't the price that the government has to pay for that claim a promise of at least trying to fairly value that claim? And if so, then how does that play into aggregate litigation?
Right. So a sort of functional outcome-based approach is going to have, right, there's a couple of ways you can slice that. I mean, one is you could be utilitarian on that end as well. You could be rights-based. And as far as a rights-based approach is concerned, certainly a utilitarian approach, you know how to travel down that road easy enough. And for a rights-based approach, yeah, you know, right. I mean, absolutely. The government has to somehow set up a system that assures a reasonably fair, in terms of accuracy, outcome. And that turns out to be a tricky business. I don't mean just operationally. I mean in terms of understanding what that means. But my view about that is an equality kind of idea. That is to say that whatever level of accuracy is given to one litigant, it has to be consistent or coherent with the levels of accuracy that are given others. So it's a comparative idea, because there's no way, obviously, we can give out, you know, nobody in this room is going to be committed to assuring as high a level of accuracy as we possibly can. It's just, obviously, we take resources from lots of other things. We're just not prepared to do that. So it becomes a matter of how much, and that's the way I would think about it.
Sir?
Robert?
Yeah, I'd like to take this back just for a moment to the... I'd like to take this back just for a moment to the first panel today. And Sheila, I'll put this question to you principally. Does this question of attentiveness to individual rights, does it play out differently, or should it play out differently when claims are being aggregated outside of tort? Now, in the Zadroga Fund, it's a pretty emotional issue for these first responders. In the vaccine omnibus proceeding on the connection between autism and thimerosal, again, a very emotional political issue. So in that context and in the setting of an administrative compensation scheme of some kind, administrative adjudication, does the issue play out differently? Should it play out differently?
Depending on the number of claimants, it has to. I mean, we thought very hard when we first approached this. Can we create a system like Feinberg had in the first system,
right,
where he met with lawyers and sometimes the claimants, but always the lawyers, and hammered out settlements, and it was more like a mediation between those people. But in the end, he only paid 3,000 some odd people, and They had they had a defined population that was easily, unfortunately, defined. We didn't know how many claimants we would have. We have 65,000 people who have registered. We have approved already over 20,000 people who are eligible and who have claims that we've paid compensation on or will pay compensation on. The way we have an individualized approach, each claim is individualized by a claims reviewer after they fill out a claims form. But we have an appeal process. It's an internal appeal process in which a claimant and the claimant's lawyer feels that we overlooked something, that we didn't give them enough compensation or whatever, they can appear for a hearing before a claims an administrative judge. It's not an administrative judge. They are retired lawyers and judges in New York who have volunteered their services and who are understand this is not an adversary proceeding. And we've had hundreds and hundreds of appeals of people who either wanted to talk to somebody or felt that their claim had not been given what they thought it was worth. And that process has worked very, very well because the hearing examiners are just really terrific, wonderful, smart, experienced people. And I've never heard one complaint about that process and how it has worked. So that's how we did it in that situation.
So one approach then might be a kind of procedural stacking, even if there isn't this right to have your grievance heard at the initial level, if there's an appeal system where there is not just a look at whether the legal issues were handled correctly, but an opportunity for a hearing, it might come at that level.
Yeah, and I think it's worked very well, and I've heard very moving stories, because I've participated in some of them myself. They're very moving stories that people want to tell, and that is, when you're dealing with these very emotional issues, that is important for people to be able to be heard. They want that opportunity very often.
Okay. Howie, you're up.
Well, when I look at Beth Burch's work, I see one of her enduring themes to be that even in mass disputes, these claims belong to somebody. Often they belong to individuals, and it's a bit too easy to lose sight of that. I am increasingly worried that aggregate litigation is a method for sucking value out of people's claims to enrich a small group of lawyers and protect defendants from liability. I don't want to overclaim. I can't quantify the problem. I can't say that it happens in X percent of class actions or non-class mass cases. But I think I can provide some structure for thinking about the problem, and I think I can help judges identify when the problem is happening. The basic structure of the situation, and the irony of the situation is this: the very thing that is empowering about aggregate litigation sows the seeds of disempowerment. So the thing that's empowering about aggregate litigation is that we consolidate control in the hands of a small group of plaintiffs' lawyers. That's what makes it possible for the lawyers to invest based on aggregate stakes. That's what gives them leverage in negotiations. But the danger is when we consolidate power in the hands of these lawyers, it makes it possible for a defendant to strike a deal with these lawyers that benefits the lawyers, benefits the defendant, but doesn't necessarily benefit the claimants. So I have a paper, I think it's included in the conference materials, the latest draft of it, or it's on the website or something, called Aggregation as Disempowerment. The title is depressing as hell. But it's, and I want to be clear that I'm not suggesting the solution is non-aggregation. The solution obviously is not individual arbitrations or individual litigation, the solution to mass disputes has to be some sort of aggregate process. But I am suggesting that there is something disempowering about mass settlement processes, at least when we look at the reality relative to what settlements would look like if negotiated by loyal agents who have the leverage to pursue claims to adjudication. This happens both in class settlements and non-class settlements, but the contours are different and the solutions are different. So Beth has a new paper that focuses on some of these sorts of problems in non-class mass settlements. My new paper is entirely focused on class settlements because I want to emphasize the judicial solution. I want to emphasize the possibility of judges addressing this through 23E and 23H, through control over settlements and fees. And to the extent the paper does anything useful, I think it's this, that it really tries to focus on specific settlement terms, specific features of class settlements. And my thinking is this. I've written a lot about the procedural logic of class actions or the ethical logic of aggregate settlements. But in general, I've steered clear of saying anything about the substantive merits of particular settlements. And my thinking has always been, what can I, as a researcher, as an academic, what can I possibly say that's useful about whether this number of dollars is adequate to compensate this particular claim? And frankly, that's a hard task for a judge as well. But what became clear in writing this paper is that even if I can't know the value of claims, and therefore can't judge the overall worth of a settlement in that sense, I can look at specific settlement terms, specific features of a settlement, and I can ask, are there terms in the deal that benefit the defendant and benefit class counsel, but don't do anything of real value for the class members? And if there are terms like that we find in the deal, and I would suggest that yes, there are terms like that we find in a number of class action settlements, if we find terms like that, then we ought to be awfully suspicious about whether the deal was negotiated by agents who were loyal to the class, and that ought to be relevant to the 23E and 23H inquiries. I think it's useful to lump these sorts of settlement features into three buckets. One is settlement terms that bulk up the apparent value of the settlement in order to entice a judge to approve the deal and in order to entice the judge to award juicy attorney's fees. In that bucket, I would put empty injunctive relief, coupons or discounts or credits that are unstackable and non-transferable. In other words, that seem to be designed to make them not useful to the holders. I would put CPRE that is off-point or unnecessary in the particular case. I would put claims procedures that are unnecessary in the case or unduly burdensome. All of those are settlement features that help make the settlement face value look bigger than its actual value to the class or its actual cost to the defendant. Then a second bucket would be settlement terms that expand class counsel's franchise and expand the protection for the defendant. This would be expanded class definitions or surprisingly broad releases. And the third bucket would be settlement terms that seem designed to discourage objections. And there I would include clear sailing agreements, and I would include segregated fee funds, and to some extent I would include negotiated class representative bonuses. The name for the conference is the Future of Aggregate Litigation, and I won't offer any predictions about the future, but I will offer a hope. My hope is that the future will see fewer obstacles placed in the way of claimants trying to pursue litigation class actions, trying to pursue collective avenues to adjudication where they might then settle along that path to adjudication. And I hope that the future will see more obstacles placed in the path of plaintiffs' lawyers and defendants negotiating deals that don't serve the interests of the claimants, because I don't want the claimants to be disempowered either by their inability to collectivize or by disloyal agents. Thanks.
So first, I like Howie's ideas about getting judges to look at the terms of the agreement. Unfortunately, I could barely get them to look at the overall scope of the agreement. So the notion that they're going to actually dissect these agreements one by one doesn't seem realistic to me. Second point is one word I haven't heard all day today: deterrence. And the third thing I want to say is I thought due process was a flexible concept. And so when you have small claims, and if we're trying to do something consistent with getting the world done and have some notion of efficiency, that maybe everybody doesn't get the same due process claim for their $10 overcharge on the telephone that they get for an injury from taking a drug that both doesn't work and causes them harm.
Howie, if I remember your paper correctly, you have answers to the 2 points he just made.
So I have answers to all.
Does it seem like a setup to you?
There were 3 points, and so look, on whether the judge is going to dissect agreements, there's enough at stake in class action settlements that it's not unreasonable to expect the 23E inquiry to be a serious inquiry. We haven't talked, the word objectors has not been used, and it's an important word here, and there is an important role for objectors. Obviously, then that raises the whole question of good, useful objectors versus bad, extortionate objectors, and I understand that's a very hard problem. So on deterrence, Mike, it would be one thing if we were to look at class settlements and say, well, the class members aren't getting very much, but at least the defendants are paying as much as they ought to, and therefore we're getting the full deterrent value of these claims. That would be one thing, and maybe that would be satisfactory for particularly for very small claims. I'm not sure it would be. But my concern is that if you've got the defendant at the table and plaintiff's counsel at the table, and they're able to negotiate deals in their mutual interest, then shouldn't we expect that the defendant is actually paying less than the defendant ought to pay? That if what they do is bulk up the deal with empty injunctive relief or CPRE that is somehow useful to them independently, or other features that I discuss in the paper, then shouldn't we be concerned that the defendant actually is getting off too easy, that the defendant is using using plaintiff's counsel and plaintiff's counsel's self-interest in order to buy res judicata on the cheap? I'll leave it there.
You happy with the response, Alvin?
No, but I've taken enough time for now.
You're quitting the field.
I don't know, Alan. This is not to make lawyers rich who are prosecuting or defending these cases, but to provide some adequate remedy for the plaintiff who's bringing the case. I'm constantly aggravated as a consumer when I get correspondence in the mail telling me I'm a member of XYZ class and fill out this piece of paper, which you can't fill out because it's impossible to get the information to properly put in the information to qualify as a claimant. It's designed that way. And then I read the rest of the paper, and the only one who's getting any real money are the attorneys on this. So I'm saying, well, what's the point of all of this class action litigation? It's not benefiting me as a consumer, and I think that should be the focus of class action litigation, benefiting the plaintiff who's harmed at the end of the day.
Howie, you're grinning.
Yeah, to a large extent, I agree, and that obviously supports my my point. I think with when you get into truly small claims, then I think we've got two different situations. One is the situation where there are meritorious claims that are worth 19 cents each. In that situation, so you've got 10 million class members, and so the overall wrong is a serious wrong, and I actually want to see those class actions pursued, and the fact that each person is going to get nothing or virtually nothing, I'm okay with that as long, I think it's useful.
But let me interrupt you for a second. But that's a fallacy, because everyone knows after this settlement is reached, the money isn't actually going to be spent. It's going to go back into the pool because you're not going to have all the claimants that were estimated to share in the settlement. So the whole thing is a farce.
Yeah, so I agree. I don't go so far as to say the whole thing is a farce, but I agree with exactly that concern, with the concern with reversionary settlements, with difficult claims processes, so that's a perfect example of a settlement designed to inflate the apparent value and not the real cost. But there is another situation, which is where the settlement amounts end up being very little, or the settlement remedies are almost worthless to the class because the claims are junk claims. And frankly, I would rather see those cases never brought in the first place. So I hope one of the effects of this paper will be to get judges to say no to approving settlements that have only junk value for the class, because I'm hopeful that that means that that lawyers won't have the incentive to bring the junk claims in the first place.
Well, my case is on appeal on that issue. It's called Lacey, L-E-Y-S-E.
Yeah, I almost feel like we're in continental Europe with the rejection of law and economics in here. Deterrence does help the plaintiffs. Even if they get nothing in the case at hand, the fact that there are lawyers that are policing corporate misconduct will help those people not be robbed in other cases. Now, they may be hard to explain to the man on the street or the woman on the street, but I think that those of us in this room can understand the concept, and so I think it is a mistake to reject deterrence as a valuable purpose behind the class action. And I think even, Howie, you would concede that in these small stakes cases, they're all about deterrence, and that's okay. The 19 cents that are legitimately taken from someone, you think that we ought to force the defendant to put that money aside and not be able to keep it.
Okay, so here's the problem with Brian Fitzpatrick. He had me, and then takes it a step too far and loses me. So the basic idea that deterrence is an important goal of class actions, including 23B3 class actions, absolutely, no question about it. But then when you say, oh, but therefore the claimants actually, it's really not their claim at all. It's just the public's claim. That's where you lose me. And what I'd say about that is there's a difference at that point between adjudication and settlement. If you actually want to bring the class action to adjudication, get a judge to adjudicate and impose some remedy where the judge decides it's administratively infeasible to get any money to the class, and following the ALI approach in Principles of Aggregate Litigation, there are going to be some circumstances where a CPRE might be appropriate. So I could imagine an adjudication.
Well, people settle in the shadow of what the adjudication would be, so I don't see why the fact it's a settlement makes it any less legitimate in your view.
Because when you're talking about a class settlement, you're trying to replicate somehow through the class process what you could imagine these claimants would have said yes to if we could somehow imagine, 1 million of them giving their individual consent where they're truly getting nothing. That's more problematic, isn't it?
Okay, we have 2 panelists to go and precious little time. Jay?
Well, I learned a long time ago that as between myself and a federal judge, the room usually prefers to hear from the federal judge. So I'm going to cede my time, at least initially, to Judge Hellerstein, and then try to pick up with whatever time remains.
You're just chickening out.
I am not.
You saw the abuse Howie took. You don't want to take the same abuse, huh?
Okay, you got me, Arthur. You got me.
Judge?
So I'd like to pick up on a number of different points that have been made this morning and this afternoon. First is the phenomenon where lots of people appear as litigants in court in an aggregate case where they're not really interested in the case, and the plaintiff's lawyer has brought them in. There are various incentives that have been noted for doing that. including building up a fee, building up position, and so on. But it's an important leveraging principle because the plaintiff's lawyer needs to be noticed and respected by the defendant's lawyers. And one way of doing that is bringing in a lot of people. But that presents numbers of problems in management of the cases because a strong element of artificiality is presented and a great deal of potential unfairness. We've been talking about some way of sampling these cases as a way of providing justice because it's impossible for any judge. I'll take my own situation. I had 11,000 first responders cases. It's impossible to deal with 11,000 cases in any fair way. So there has to be various kinds of techniques for doing that. One technique that I considered was the bellwether technique that was been talked about this morning. But I was very unhappy with that because all it meant was that the plaintiff's lawyers, for reasons that were conducive to the plaintiff's lawyers, and the defendant's lawyers, for reasons that were conducive to the defendant's lawyers, would put their favorite cases up for bellwether treatment. But they were not necessarily the best cases or even the good cases. And what is to say about all the other litigants in the case who also have cases and who may not like to see someone else's cases given preference? So I adopted something totally different from the case slips that we've been talking about, methods by where the lawyers put down the essential facts of the case. And I adopted a core discovery program treating a whole lot of questions that were worked out with a consensus between the special masters and among the lawyers, questions that had to be answered by each litigant, not the lawyers, by the litigants as if they were interrogatories. Now, of course, the lawyers will draft the answers, but the litigants have to sign and swear to the answers, and some of them will be examined on the answers, and so there's incentives to be reliable and true. Furthermore, I made these answers come forward in a way that was consistent with the sequential numbering of the cases by index numbers. Each plaintiff had to have his own index number. I did not allow a mass numbering, as some tried. And the reason for that was that there's no way to keep administrative control over cases that have lump numbers. Each case has to be given its own number. And in order to have each case identified, the answers had to come forward in a way that was resembling the number, in sequence to the number, so that anybody who missed the number, didn't do his answers, was dismissed. 10% of the cases were dismissed. That's an amazing number. Of 11,000 cases, over 1,000 were dismissed because the particular plaintiffs did not want to go through with the program. Furthermore, it enabled me to create a database for the case so that the essential facts of the case, not all the facts, but the essential facts of the case were commonly known to everybody in the case, to me, to the outside, to every lawyer in the case, and not only the representing lawyers, but all the lawyers and all the parties, all the litigants. Everyone had the same facts, and everyone knew where the case was. And then we chose, by sampling, the bellwether cases. Bellwether cases for accelerated discovery, fixed trial dates coming at the end of it, and a great deal of information known for each particular person. So when it came time to start culling this information and looking at it and projecting what the answers were likely to be, we were amazed because not only the 10% who didn't participate, but approximately another 20% of the cases had no objective indication of injury. They were there for the ride. Many of these cases were brought back in the settlements because there's a value in a release, even where a case does not show any particular damage. But by this method, we were able to find out which were the serious cases, which were the good cases, and which were the cases that were not worth very much treatment. And that brought about a mass settlement because the lawyers then knew the information, they knew how to value the information, they had my set of priorities in terms of which cases to favor by putting on a good deal of money on it, in which we're just there for the ride. The variation was $3,250 on the low side to cases of several millions of dollars on the high side, graduated according to the severity of injuries and the likely ability to prove causation. So instead of accepting each plaintiff as a legitimate plaintiff, I took a different course and dealt with skepticism about many of the people who were put forward as plaintiffs. I wanted the real plaintiffs to be able to address their injuries and to have their discovery, which was as close to a day in court as I could get in this kind of a system, and create a plane of equality among all the cases to try to create some articulable way of measuring recoveries and measuring the cases that would go forward. There was talk before about phony settlements and real settlements and how to discover what's real and what's phony. Well, it's impossible for a judge to know what's a fair settlement, really. The judge is the party with the least information about the case, and you have to approach any number that comes out as a realistic number in the sense of arm's length bargaining. There was arm's length bargaining, but also has to be realistic. Where was the leverage? Who had the greater need for the settlement? As between the defendants who were being paid as they went, according to time charges and mass arming of the cases by all kinds of lawyers and paralegals. You had the plaintiffs' lawyers who were carrying the case with financing. This kind of financing was factored financing, interest rates 16 to 19% compounded yearly, secured by the homes of the partners in the plaintiff's lawyer's case. And they carried the case forward, but they had a need to settle. If they hadn't settled, they might have gone bankrupt. They may not have been able to run the case. Here was a frustration on the part of the judge who thought that the defendants were overdoing their defense as a way of wearing down the plaintiffs, and the plaintiffs had no intake procedure and were not putting enough money into knowing all the essential values of the case and trying to slip things by. There was an inequality that was basic to the problem. But that's not enough to void a settlement. It's not enough to enable me to say the settlement was unfair. Here I had another piece of information. I knew how much money FEMA had put up for the captive insurance company. It was $1 billion. And if a settlement comes in short of $500 million, ostensibly leaving something for the future, I had the strong sense that too much was left for the future. Too much was given for the plaintiff's lawyers and contingent fees that were untouchable by me, and too many, as Howard calls them, of clauses building up the potential for res judicata, releases, and the like. So I avoided the settlement. I did not approve it. What's my authority to approve or disapprove a mass settlement? You can't find it in the rules, and you really can't find it in the cases. Judge Weinstein has done a number of Cyprexa, and I think a couple of others, calling them quasi-class actions. I didn't like the term quasi-class actions. I try to figure out particular settlements and compare it with other kinds of settlements, and I got nowhere. But what I thought was really important was that the plaintiff's lawyers, representing in this one firm 90% of the cases, had no way of presenting fairness among his clients. He could not distribute the settlement in any particular fair way. And I thought he was compromised also by the fact of having to carry so much debt forward in the case. So I felt, given the amount of money that was kept back and the conflicts that I saw in the plaintiff, that I had the ability, as the only party who had any sense of the whole and could feel any aspect of fairness, I had the power to act. Furthermore, the settlement required a very high threshold of approval, and unless I approved it, they were never going to get it. Ultimately, we had a 99% acceptance rate. There's nothing in society that I know that gets a 99% acceptance rate. I went out with all the lawyers and the special masters, the court reporters, and the marshals. We went out to 2 locations closer to the plaintiffs to present the settlement, to explain it, to hear the cases, to hear the grievances, and to gain understanding on the part of those affected by the settlement what the revised settlement was and how I thought that, although not perfect, it was fair. And I backed and supported it. And ultimately, we got this very high rate. So trying to leave some time for Jay, the points I want to make, it's important for the judge to have a process by which all cases are heard. It's important for the judge not to be totally reliant on what the lawyers tell the judge, but to find some independent and transparent way to measure the cases and get a sense of the size of the cases and the value of the cases and the merits of the cases. It's important for the judge to create factual information that will enable a transparency to be applied in measuring who gets what in the settlement, so that there is fairness not only in the whole, but also fairness in the particular. And it's important to have some kind of a procedure, and I think an appellate procedure is important as well. There cannot be arbitrariness in any part of this procedure. People have to know that when they go in, they've got a fair chance to be heard, not necessarily by the judge, but at least by people who are in the business of giving out the money. And it worked. Ultimately, not one case was tried. I had different categories of cases. I had the cases where Sheila was involved in, the wrongful death, personal injury cases of those who died in the crashes. Each one was individual. I tried, particularly in the beginning, to adhere to the values that Kenny had established with the Victims' Compensation Fund, because I did not want to create a situation where people could see that if they did not settle with Kenny, they would have gotten a lot more money in the litigation. I felt that that would create a strong sense of disapproval and disenchantment with the courts and the process, and I thought this is a sufficiently public event that we would not allow it. And then as the cases went by and lawyers tried to leverage on the settlements to get more money for the fewer and fewer cases that remained, they tried to get more money, and I disallowed those settlements. I had a leverage because all the settlements diminished the limited fund that was available for all settlements, so I had to approve all settlements. And I rejected some because they were too high. And ultimately, it was as important to get a distributive justice as anything else. Sheila will remember people who came in who wanted to be assured that if they settled, they would be not looking foolish, that they were getting as much money as other people were getting. And I was able to give them that assurance. And then there was the business of limiting fees, because a great source of disenchantment is that at the end of the day, the lawyers are getting more, or almost as much as the plaintiffs who suffered an injury, and we regulated the fees as well. I think there is a great deal of importance in taking these cases and treating them not as a locus of aggregated cases brought to the particular court, whether it's directly through operation of law, as mine was, or whether it's through a procedure that Judge Vance presides over, the multi-district litigation, and treating these cases, and this I learned from Judge Weinstein, not as a game to be played in court, but as numbers of claims presented by real individuals. The judge has a job to distinguish between the real claims and those that are just there. And the judge has a job to make sure that each claim is advanced in some way to be heard. Now, heard is a complicated word here, but heard in the sense that it is given sensitive and understanding treatment in relationship to every other case. And to create a process that's fair and open. When court sessions are called, they're called with notice on a web page so all can hear, with the participation of the press, which is a great arm to the judge, because reporters will tell the judge different things they hear from the litigants, and then a hearing can be created. So all this is put on the public record, and it's a discipline of the lawyers with respect to proper representation of their clients as well. It's a very complicated business, but I think unless the judge is the enforcer of transparency, the applier of fairness and justice, the system can too often run into the kinds of abuses that my fellow colleagues talk about in their learned writings.
Jay, you have at least a minute, minute and a half before we're kicked out of here.
2? All right.
Go ahead.
So very briefly, let me just summarize, first of all, by saying this is, I think, a critical issue. Howie has mentioned how Beth's work over the years has really informed this question about the role of the individual within the aggregate, and it is, I think, at the center of much of the debate. It seems to me there are two fundamental issues that are involved here, and the first, I think we heard from Tom and from Bob, which is the 30,000-foot theoretical question about if we assume that people are being disempowered, do we care about it, or the extent to which we would care about it? What's the theory? The other is just the very stone-kicking pragmatic question about what kinds of mechanisms of loyalty, voice, and exit we're actually going to adopt. And I know Judge Hellerstein has mentioned a few. I'm not as pessimistic as Howie is about the fact of disempowerment. I think he describes a reality, but not necessarily that which must be going forward. I don't have the time, obviously, to spend very long talking about it. I'm going to mention just one idea, and I'll do it very quickly. It is a loyalty strategy. I don't think voice strategies work well, except in the groupie areas that Bob has talked about, and they're hard to define. So really, you're limited to loyalty and exit strategies for the most part on the ground. One strategy I think that is critical, Judith mentioned it, the judge mentioned it as well, is getting a control over attorney's fees. There has to be a mechanism to align that incentive. I think it exists, actually. I don't have the time to explain it. It's based on an article by Kevin Claremont many years ago. It has to be tailored to this particular situation of complex litigation. The basic idea, though, is instead of using a lodestar or a percentage of the fund, which are the two main approaches, you actually use them both. You calculate the attorney's fee on a reasonable hourly rate times number of reasonable hours worked. You then figure out the multiplier by applying a percentage of the recovery, of the net recovery, and that actually perfectly aligns the incentives of the lawyer to the group in a number of ways. I can't explain it any further than that, so I'll leave it at that for now. Thank you.
All right, with the unlimited power of the moderator, I hereby declare this panel unemployed.